she defaulted. They got a default judgment. She appealed the default all the way up to the Supreme Court and lost. He ain't got anything to do with her default judgment. She had a duty to answer when she was served. So a lot of this was created by her own doing.
Your Honor, I have to stop right now and tell you that in his bankruptcy deposition, he stated he gave $3 million in assets away to his father with no consideration. He tied it causally to the debt that he put on his wife, and she's about to lose her company up in New York.
Okay, so what I'm going to have each of you do, I think these issues can be consolidated. All right. We're on the record in cause number DF1308991. Counsels, will you please announce for the record?
Good morning, Your Honor. Gregory Franklin on behalf of the plaintiff, Renata Black.
Thank you.
Honor Mike Gruber also for the plaintiff, Renata Black.
Counsel.
Brett Stalkup for Wade Black.
All right. And those who intend to testify, please raise your right hands. Do you swear or affirm that the testimony you'll give will be the truth and the whole truth? Oh, you have to take yourself off mute.
I do.
Thank you. And counsel, your client is not present. Is that correct?
That's him.
Oh, who?
On the top right corner.
Okay, Mr. Black. Attorney Franklin, where's your client?
She's not attending this morning. Let me send her a quick note.
Are you all putting on testimony or just argument?
This argument, Your Honor.
Okay.
Well, I understand that we submitted the exhibits as evidence last Thursday, which you have before you.
Correct. And those were pre-admitted and they will be admitted at this time. We have petitioners exhibits 1 through 22 that are admitted and respondents exhibits A, B, and C. And just so the record is clear, this is a hybrid hearing. So we have the plaintiff's attorneys on Zoom. The respondent is also on Zoom and the respondent's attorney is present. Well, attorneys are present here in the courtroom. All right, Attorney Franklin, did you want to proceed with argument?
Yes, Your Honor. I would like to share a presentation as I think it would aid the court.
Okay, go ahead.
And when Your Honor is able to see it, if you can confirm in the affirmative.
Yes.
Your Honor.
Go ahead.
Okay. Your Honor, for 8 years, Wade Black has run a shell game. Every time a court tells him to pay Renata, the money vanishes into his father's name, into a bankruptcy, into a company that gets sold, and now into a luxury airline that he swears he doesn't own a piece of. He has paid everyone but her. And when he's placed under oath, he doesn't just refuse to pay. He continues to evade accountability and responsibility. This is a man who will move assets and shade the truth to make sure his ex-wife never sees a dollar. The decree that this court signed back in 2018 ordered Mr. Wade to pay Renata $1.8 million to turn over specific property and to defend and indemnify and hold Renata harmless for liabilities that he is responsible for. He has paid none of the money. He has not defended or indemnified her for any of the cases that's being pursued against her, in which he is duly obligated to do under the divorce decree. And so today I'm going to make a few points. First, that the decree in itself was clear. Second, that the record proves that his noncompliance is willful and intentional. He's had the means to honor the divorce decree. He has the means, but he has continued to conceal it. And third, that Mr. Black needs to be held accountable. And I'll submit to this court that he should be held in contempt for the money that he owes. And Renata is entitled to judgment for her fees, her attorney's fees, as well as the past obligations that's due to her from Mr. Black.
Thank you, counsel.
I'm trying to advance the slide now.
Oh, okay.
Okay, there we go. Now, over the last 8 years, this is an analogous to what our client has heard. In a recent deposition, we asked the respondent to admit that after the bankruptcy began, he told Renata that he was unable to pay for his obligations under the divorce decree. And asked, was that accurate? He said yes. So over these years, he said he has not had the ability to pay, and it has shown up and manifested in him not sending her a single dollar or acting and performing specifically under the terms of the divorce decree. So Mr. Wade Black has showed a pattern of evasion. And I don't want to get, just for context, I don't want the court to think that Mr. Wade is somehow a pauper or doesn't have the means to do so. So let's talk about who Mr. Wade is. And Mr. Wade is the CEO and co-founder of Magnifica Airlines, which is a luxury jet company in which he owns 10% stake in the company. In 2025, he earned at least, what we can tell, over $400,000. And to date, in 2026, $640,000. He and his company has several jets that they've leased in order to operate this company. As you can see, it's a private and a luxury brand. But it's, in terms of the divorce decree, as I mentioned, it's very clear in its terms. Mr. Black, in the divorce decree, he received the property at 6331 Luton Drive. It is in Dallas, Texas. And he was also given responsibility of the promissory note that's tied to that particular property. In a relevant portion, it says under the order that Mr. Wade, the Black, shall indemnify and hold his wife and her property harmless for any failure to discharge of the promissory note. Furthermore, under the divorce decree, Mr. Black was required to pay $310,000 to his wife on or before the date of entry of the divorce decree, and he was required to submit annual payments to his wife in amounts of $258,000 a year, starting on December 31st, 2026, through December 31st, 2021, with 5% interest, plus any reasonable attorney's fees incurred by his wife in trying to collect the amount due. Under the divorce decree, he was supposed to securitize or back up the amounts that's owed on an annual basis with his stock that he held in 7 Bar Enterprises. And one of the key features in duties of Mr. Black, he was ordered that if any claim of action or proceeding hereinafter initiated seeking to hold the party not assume the debt and liable for such debt, that the other party at his or her sole expense defend the party not assuming the debt. And he would indemnify the party not assuming the debt and hold that person harmless from all damages resulting from the claim demand. He's done none of that. But here today, this is what's not in dispute. It's not in dispute that Mr. Black admits that he's failed to pay Renato Black the $1.8 million plus the interest as required by the divorce decree. And Mr. Black will admit, as he has, that he has not defended or indemnified Ms. Black against any lawsuits involving the liabilities defined in the divorce decree. And as the court knows, that the primary item of controversy here is the defaulted promissory note, and that our client has been forced to defend herself over the last several years. And Mr. Black had knowledge of this default. He has knowledge of actions that have taken place in New York that has subsequently jeopardized our client's company, EBY in New York. But again, he's failed to do anything and act in a manner that would protect her interests and defend her under the divorce agreement. So it's all been a shell game. Wade pays everyone but Renato. So here's the timeline of how things have shaken out. And it also demonstrates the efforts that Mr. Black has taken place to avoid paying or honoring the divorce agreement. In 2023, according to his own testimony in a bankruptcy court, Mr. Wade, at the end of 2023, he was worth $26 million. In 2025, the parties executed a CMSA, and in December 2016, Mr. Black transferred approximately $3 million in business interest to his father. Rolf Black. And just a couple weeks after he did that, the first payment to Ms. Renata Black was due. He failed to pay her.
Was what?
The payment was due and he failed to pay her.
Mr. Franklin, you're a little muzzled or muffled.
Muffled.
No, muffled.
Muffled? Is this any better?
You're not as clear.
Mhm.
Can you hear me?
Yes, go ahead.
Yes.
Is that better?
It's
Yes,
okay.
when you speak louder.
Okay, I'll speak louder is this better?
Yes.
Okay.
Now you're killing me.
All right, so in June of 2017, he files for bankruptcy. And then December of the same year, he still failed to pay the second $258,000 that's owed to Renata. In July 6th of 2018 is when they finalized the divorce, in which Mr. Black was required to pay a lump sum of $310,000. He didn't do it. But just a few weeks later, not even 2 weeks later, he creates this Black 2018 family trust that he created with his now wife, Sarah Bradbury, as co-trustees and beneficiaries. And this is going to be key to later testimony or argument. As I mentioned, for that period of time, he never made the $258,000 payments. And then in July 24, 2019, Lakeland Capital, a third party, purchased a promissory note from the bankruptcy court for $20,000. Lakeland filed suit in September of 2019, and he sued both Wade Black and Renata Black under the note. But somehow in March the 2nd in 2020, Lakeland Capital non-suits Mr. Black for whatever reason, and kept Renata Black in and had default judgment entered in against her. Wade admits that he was aware that this default judgment was entered against Renata, but yet he still did not pay or try to defend her in any of the cases. By March 28th, 2023, he formed Magnifica Air One, which is the luxury airline company. May 30th of 2023, Renata informs him that the receiver that was a part of the Lakeland lawsuit, that was appointed in the Lakeland lawsuit, was trying to collect the default judgment through her company, EBY in New York, which caused huge disruption. I believe her accounts were frozen. The investors all received notices, was caused is a huge mess, and it's still a mess. Her company still, I mean, they're fighting under the pending litigation, and that could essentially disrupt or jeopardize the company as a whole. By June 18th, 2023, Wade promises himself the default judgment with the receiver. He doesn't do it. Wade, in October the 4th of 2024, Wade was informed that the IRS was pursuing Renata for $165,000 for his unreported business income for 2015. And to date, he still hasn't paid that or reimbursed her for those charges. And on May 1st, 2025, we found through the evidence and exhibits and that Mr. Black created a operating agreement and which memorialized that the Black 28 Family Trust owned 10% ownership of Magnifica Air, and it made a $100,000 contribution. And by October of 2025, I mean, his airline was in the press. There's news of this luxury airline having multiple jets that will be operating fairly soon. And then in January of 2026, Lakeland took this case and formalized it and filed suit in New York to attach the default judgment to her assets, which includes her asset, the EBY in New York, and also got a TRO against Renata. Wade knew about this, but was formally told about this on April 19th of 2026. Over this period of time, Renata consistently has requested indemnification for to be paid and hasn't done it. And then on June the 1st, 2026, we sent our final request for him to honor the demands to honor the divorce decree. And to date, he refuses to do so. And this deception continues. We just had a deposition last week. We initially tried to set one up earlier this month on the 7th, but Mr. Black no-showed, but we were able to get one set for the 22nd. And at this deposition, which clearly indicates what his intent is to cover up on the truth, he was asked specifically, all right, admit that you held an ownership interest in Magnifica Air since January of 2023, and you denied that. And this was based on his responses to his request for admissions. He said, correct. So you don't have ownership interest? He said, I do not. And to clarify, the questioner asked, as of that time, he said, I do not. And even today, you don't have an ownership interest in Magnifica Air. He specifically says, I do not. Okay. And then when we asked the questions about the 2018 Black Family Trust, the question asked, did you transfer any assets that we've discussed into the trust back in 2018? And anything from any of your other trusts or property you got from your family, anything like that? He directly says no. So do you know just approximately the value of the assets you put in the trust in 2018? He says a trust was created with a gift of $5,000 from a friend of mine. And it was asked, so over the last 10 years, since you established the trust or whatever time period, approximately how much money have you put into the trust? He says, me personally, none. So how much money has the family member, friend, anything along those lines put into it? And he says none. But here's the truth, Your Honor. Back in at least 2015, 2025, but I believe prior to, because we're still examining the evidence and exhibits from a late discovery, it shows clearly here that the Black Family Trust didn't just have $5,000 in it. It had at least $100,000 to contribute for a 10% interest in the airline. So today, Your Honor, the court is the petitioner and plaintiff, we're asking the court to hold Mr. Black accountable. Whether it's contempt and commitment, daily fines until Mr. Black purges himself of contempt, or an alternative, money judgment for outstanding obligations on the divorce decree, and attorney's fees, and for anything else that the court sees fit.
Thank you, counsel.
Your Honor, I'm sorry, this is Mike Gruber. Could I add just a couple of things if Greg's tied up for now?
No, we're going to allow the respondent to respond, and then you can add to at that point.
Yes, Your Honor, that works fine.
Okay. Counsel, you may proceed.
Judge, I've been in this case for about 2 months. It's could be in front of you. I first started by asking the client, how in the heck did it get here? They did Kevin Fuller mediated the case for him in 2015.
Mm-hmm.
And then the decree wasn't signed until 2018. And he made large commitments to her at that time. He signed the decree, right? So they were under the debt obligations portion of the decree. There was no accounts that were specific that were included in the decree. In the debt obligations, he was promising to pay forward. At that time, he had the money and the plan to do it. He had a great job. He owned a company. The private equity firm 3 weeks later yanked the rug right out from under him. They stopped paying him. He lost his house. He lost his cars. He lost his boat. He lost everything he had. Then in 2023, he had major heart complications. He's going to have a valve transplant. But the good news is, Judge, he's got a great job in Florida. He's making $45,000 a month. He's testified at the deposition. The payment obligations in the decree are part of property division and debt obligations. They do not direct Mr. Black to deliver existing monies for specific funds at that time. And in family law, we all know it's a future installment. The amounts of the indemnity and the reimbursements remain in litigation as plaintiff defaulted. She defaulted. They got a default judgment. She appealed the default all the way up to the Supreme Court and lost. That's where all the attorney's fees came from. When she defaulted, she precluded Mr. Black from any opportunity to defend himself or her and her in that case. So he's dealing with the final judgment from default. He hasn't paid everybody but her. He's got himself back up on his feet. He's got a $2 million judgment against him in Florida. We have a BK here in the Northern District. In the BK, there's a pot of gold. It could be anywhere from $750,000 to $3 million. All the debts have been paid. It's our job to work together collaboratively to make sure the bankruptcy trustee doesn't spend that money on herself. That's what happens in a BK. So we got that
BK?
bankruptcy court. So I talked to the council last week about it would behoove all of us to work together. He's got a good job. He's got good people he's working for. We're trying to get it to the table, to mediation. Lakeland Company is scoundrels. They're out of Waco. They go and pay $20,000 for a note in BK court, and they're up to 1.8 million. I don't know what deficiency they have over $21,000. So we have to fight that. But Mr. Black has been talking to Lakeland. Lakeland's lawyer, I just got the name of the Lakeland lawyer in North Dallas. Good Waco Baylor lawyer. I haven't had time to call because I've been fighting this all the last 10 days. But Judge, he's trying to get everyone to the table. If Mr. Black can't leave his ex-wife out here in the alley with her judgment, Lakeland has to go away with her and him. And it's going to take it. We might even have to bring Lakeland in this court to get it where they're going to come to the table and a court order mediation and work with us.
Let me stop you right there, counsel. Why, and either of you can answer this, why isn't Lakeland included in the suit?
Because I've only been there for 2 months. I haven't had time to figure out the game. They should be.
Attorney Gruber or Franklin?
Judge, they're actually, if I could, they're actually the plaintiff against our client, and just to show a little bit of what's going on here.
That was just my
okay. All right.
question.
Yes, the answer to your question is there is a suit. We are thinking about bringing Lakeland into this. We think there's some issues with jurisdiction because Judge Parker has this Lakeland in their court where they were the plaintiff. They got a default judgment while Mr. Black had the obligation to defend him, and he, instead of defending her, she's now set up with his debt that was awarded under this. It's a debt tied to the house, $2.7 million house. He got the house and the debt associated with it. That they've now liquidated the house, and he didn't pay off the debt because he put that debt on her. He didn't defend. She got a default judgment at the same exact time in the same document that he got released out of it. So there's a whole lot more to that. But she is in Judge Parker, or Lakeland is in Judge Parker's court trying to chase my client for 4 years. And right now, this debt is pending in the New York court.
So the case with Lakeland against your client is pending right now in front of Judge Parker?
It is, and in New York. Lakeland has gone up and is trying to take my client's stock, her share in a company she created. And they're going to lose that. She's going to lose that. And that could happen any day now because Mr. Black never defended, never got involved, and he hadn't paid it. And what's crazy is the amount is...
Hold on 1 second, counsel. I wonder if it wouldn't surprise me if Judge Parker refers that case down here to the family court, because it sounds like Lakeland is a necessary party in this case. That's just me speaking out loud because that happens a lot. Something in the civil court ends up in the family court. So put a pin right there, counsel, and I will let Attorney
Finish my argument?
Yes, go ahead. Go ahead.
Judge, in our response, we've included multiple cases in family law and a Supreme Court case that lays out that confinement until installment arrearage is paid is impermissible imprisonment of a debt. Ex parte Yates sets that out perfectly. So, and the other thing is, for them to argue to put him in jail, are you kidding me? That's the worst thing could happen for her, and could happen for him, and it could happen for Lakeland. He'll lose his job. We're back to square zero, where he's on the food line. So he knows his obligations. He's wanting to help his ex-wife. He's finally in a place where he can get himself out of the ditch, Judge. Thank you. Oh, Judge, that default judgment, he ain't got anything to do with her default judgment. She had a duty to answer when she was served. Everybody knows that. Every business person knows that. So a lot of this was created by her own doing. And to ask and request him be jailed by contempt is totally out of the spirit of working together to get this in one place and get it settled. That's what needs to happen. And pick a good mediator, make it go away.
Thank you. Does that conclude your argument, counsel?
Yes, ma'am.
Okay, Attorney Gruber, you can now pick up where you left off. I would just ask in your response, could you tell me the status of the bankruptcy, if there's still any, and what makes Mr. Wade's behavior a shell game?
So, Your Honor, here the bankruptcy is essentially concluding there is money in the bankruptcy, which Mr. Wade, as the debtor, has some control as to what happens. For example, there's the $2.7 million house that was awarded to him, but this debt we're talking about was essentially the mortgage on that house. He's liquidated in the bankruptcy of the house, but he didn't pay the debt. And the reason he didn't pay it, and we're talking about innocent, he's innocent, he doesn't have anything to do with this. He convinced his ex-wife that he would do the negotiations. There's plenty of evidence that he's telling her, I'm going to get this settled for you. I can't tell you exactly how. I'm going to get this settled for you. So what does he do? He says he was aware of the default judgment. He said he was aware that they were chasing her before the default judgment. He had the duty to defend the debt that was his under the court's order. And instead of that, miraculously, he has her, she gets the default judgment, even though he knows they've sued both of them at the same time. And on the same day they take a default judgment against her, they release him. Now he's negotiating for her. He's doing a really good job. So that's a real problem. But they've talked a lot about this is just a debt. Your Honor, there's a whole lot more to it. Their constructive trust are all over this. As we said, within 30 days of his first payment being done, he gives away. It's not a transaction, not arm's length. There's no consideration for it. He gives away $3 million within either days or weeks. They say sometime in December. At the end of December, he owes her the first big payment of $310,000. He gives away $3 million. Well, and then he goes into bankruptcy. I'd go into bankruptcy if I gave away $3 million. I could claim I didn't have any money anymore. So he does that. Okay. So now he makes no payment. And what does he admit in his deposition? We ask him, well, wait a second. Does the $3 million that you gave away, did that affect your ability to pay your obligations under the divorce decree? Let's take first the $310,000. Yes, I would say that certainly affected my ability to pay that debt. Okay, and then we went through every single debt in this thing, and we asked him, would the fact that you gave away $3 million, I'm glad somebody's getting gifts, Your Honor. Did that affect your ability to pay the debt? Every debt in this thing we went through, and we asked about it. And Your Honor, let's take this debt that was put on her that he was supposed to defend. He had an obligation to defend. He knew it needed to be defended. And again, he took over the responsibility for settling it with her because it's his debt, and ends up that he gets released on the same day she gets the default judgment. Sure, that's a coincidence, Your Honor. But the debt is part of the secured by the deed of trust and all that type of thing. My understanding is they took the $2.7 million house, they sold it, and they paid off debts. But this is the one debt that they didn't pay off, and he has a lot of control as the debtor in this situation. And so again, we're talking about not a just debt willy-nilly out there. This is a debt on the property that he took that was secured by a deed of trust, and now she is having to pay that amount under this default judgment that, again, he was supposed to defend. So that's not just an outstanding debt. That is a debt tied to property that should have been paid with the $2.7 million that is actually tied to this specific debt that is on her now, and that wasn't done. And again, besides the construction trust, by getting rid of the $3 million right before you've got to pay all these obligations under divorce decree, once it hits, the other thing, there's a constructive trust because in 2018, again, right before he's supposed to make all these payments, he creates a trust that he says doesn't have anything in it, but actually now has in it. We can't even imagine what this is worth. 10% of a luxury airline that is in the process of leasing 6 Airbuses, over $1 billion worth of aircraft that they're leasing right now. They've already got one leased. It's in the background of all the photos of him, and he's showing it off. Your Honor, this is not typical debt all the way through this thing. It is not just debt. It is tied specifically to obligations he was had to pay, and he avoided. And if that's not a shell game, I don't know what is, Your Honor. Everything he's done in this thing is to put a debt on her that was his debt, and to avoid payments by giving money to his new wife and kid in this trust they set up, and to his father for no consideration, just because, for 30 years of taking care of him like any father would do. Thank you, Your Honor.
Thank you. Response.
That $3 million, that is not true. That $3 million, he might have transferred it went to BK Court. So to say that he gave $3 million away and avoided to pay her, that's not true.
Do you have any proof
It's in the
of
BK
payment?
court. It's in the BK court, bankruptcy court. We can provide it to the court. But the other thing about that is, Judge, there were 2 notes on the house. Not one, there were 2. Okay, so the house was sold. It was in bankruptcy court. Family law matters don't go into bankruptcy court. I didn't know that. I don't know BK law. But everything that's been paid has been paid in bankruptcy court. And that's part of where that money, the pot of gold, has come from, was the $3 million was transferred back to bankruptcy. He didn't at his own discretion pay who he wanted to. That is not true.
Your Honor, I have to stop right now and tell you that in his bankruptcy deposition, he stated he gave $3 million in assets away to his father with no consideration, only 30 years of his dad taking care of him. The other day, and we can pull that up if Mr. Franklin, has it handy. He said, yes, I gave $3 million away to my dad. And specifically, I did that and he said it's in December of 2018, I believe, or 2016, right before this thing went into the decree went in, right before, within days or weeks, but no more than 30 days before this obligation, the first one came in, he acknowledges he put that money away, and he acknowledges in that on that payment and every other payment, it causally could have kept him from being able to pay her obligations. That is not simple debt. There's a constructive trust right now. If you give everything away is a gift to your dad right before your obligations kick in under a divorce decree, I would say there's constructive trust in that situation, which is one of the things that keeps it from being a normal debt. And again, it is tied to the house. This is a debt, if you read the divorce decree, that's tied specifically to the house. And again, the benefit of the house went to Mr. Black, and he was able to have that liquidated to pay debts. And and he said in his deposition, well, we can only go by what he told us in his deposition. In his deposition the other day, he said it didn't make any sense to him that didn't pay off this debt. He tied it causally to the debt that he put on his wife, and she's about to lose her company up in New York. He specifically said that the debt in question, he doesn't understand how it did not get paid with all the money that the house was worth. That's what he says. That's his story. It's not mine. And we can pull that up also. It's not a very long deposition, Your Honor. We'd love to highlight the parts that we've gone over today for you after the hearing.
And if it pleases the court, Your Honor, I've pulled up the deposition transcript from the bankruptcy court whereby Mr. Black testifies that he gave $3 million to his father.
Okay, so what I'm going to have each of you do, because I found, I mean, the motion for contempt is super long. And I think these issues can be consolidated. So I'm asking each side to, I'm asking plaintiff side to brief the issue specifically regarding the promissory note, because in the response, it says that the court, is this the response? Hold on, let me make sure this is the response and not the motion. I read that the bankruptcy court under Chapter 7 is still pending,
Yes.
but the Chapter 11 is discharged.
Don't leave me to lie, because I don't know the difference between 11 and 7. There's an action in the bankruptcy court that's still pending.
Okay, I think that's the Chapter 7. Attorney Franklin, is that your understanding the Chapter 7 bankruptcy is still pending?
Yes, it was either converted from 11 to 7 or 7 to 11, but there's still, the case is still pending. I don't think there's any live issues. I think that the trustee just needs to wrap the case up, because I don't think there's any additional claims on it. So we're just waiting for the trustee to close the case.
Okay.
But yes, it's still a live case in the bankruptcy court.
All right, so
Your Honor, we've gotten a motion. We did get the court to lift the stay specifically to conduct this litigation. So we have no issues there, and there really are no further issues. The last one was the last couple of weeks, and it affected Mr. Black favorably. So the debt as to him has been taken away by statute of limitations. Unfortunately, under the divorce decree, he was responsible for the debt. He's still responsible for the debt that my client is settled with, and she may lose her company over as soon as this week or next week.
So the court is clear. The orders that you're specifically asking the court to enforce are the promissory note, the initial lump sum payment to your client, the failure to make the 6 annual payments to your client, the taxes, and the failure to defend, indemnify, and hold are harmless.
Yes, Your Honor. And between the admissions and the deposition he gave you the other day, and 95% in the admissions, he's admitted every bit of it without defense. Okay,
so that is what is that specifically outlined? Because you all have a lot of exhibits. And I think if you all were able to brief that issue with specifically highlighting and referencing the transcript line, that would make this a lot easier, because that motion for contempt has a lot of information in it that's not necessarily related to the contempt action itself. And I don't want to further complicate any issues. So if you all were to brief that, if you can do a brief that's less than 6 pages, that would be great. And counsel has an opportunity to respond.
Thank you, Jerry.
We will do that right away, Your Honor. Mr. Franklin just we canceled the rest of his day. So
okay. How soon can you all get me that brief?
Realistically, by Thursday or Friday, Your Honor.
Okay. So let's do this. How about Since nothing is pressing in the bankruptcy court, I'll give you all some time just in case you need more than Thursday or Friday of this week. So how about the brief is due by Monday of next week?
That works for me, Your Honor.
All right, great. And then counsel, if you can get your response in as soon as possible, and then the court will take a look at those. I can give you all a reset date. So we can reconvene and I have an opportunity to review the brief as well as the response.
Do it around August 8th. I'm going to Jackson Hole.
Oh, no, it won't be around that time. I have August the 24th, August the 31st, and September 14th.
Honor, the 24th works better.
The earliest, if that's the earliest date, we'd like that one.
Okay, the 24th of August.
No, because Mr. Gruber wants the 24th. I want the 31st.
I knew it. I will say this, counsel has had kind of a tough hand handed to him, and he couldn't have been more professional. He's tried to do everything he could to fulfill his obligations. So to us.
I did all that, Your Honor. He's been the consummate professional.
That's good to hear.
I don't have to go to jail. 24th.
Okay, the 24th, is this in person or on Zoom?
Yeah, let's do that in person if that's okay.
Okay, 11 o'clock.
Okay, that works, Your Honor.
Yes, Your Honor.
All right. Yes, you all are excused. I have reset you for Monday, August the 24th, 2026 at 11 a.m.
Thank you, Your Honor.
Thank you,
You're
Your Honor.
welcome. You're welcome. Y'all have a good day.
Thank you.
You're welcome.